Welcome to the Law and Liberty podcast. I'm your host, James Patterson. Law and Liberty is an online magazine featuring serious commentary on law, policy, books, and culture, and formed by a commitment to a society of free and responsible people living under the rule of law. Law and Liberty in this podcast are published by Liberty Fund. Hello and welcome to the Law and Liberty podcast. Today, my guest is Ilya Shapiro, a senior fellow and director of constitutional studies at the Manhattan Institute. He was executive director and senior lecturer at the Georgetown Center for the Constitution, and before that, vice president of the Cato Institute and director of Cato's Robert A. Levy Center for Constitutional Studies. Today, we'll be talking to Mr. Shapiro about his forthcoming book, Lawless, the Miseducation of America's Elites, which should be coming out very soon after this podcast. So be sure to look it up on Amazon.
By the time this airs, I think it'll already be out. January 14th is the pub date. So Lawless, the Miseducation of America's Elites. Go get it in any and all formats. That's right. So for those of you who need a little bit of schooling about self-promotion, Mr. Shapiro has provided you excellent example, be on top of all this stuff. So anyway, welcome to the podcast. Good to be with you, and it was good to recently hang out with you and talk deep thoughts at a Liberty Fund retreat about the future of fusionism. And I'm happy to discuss the illiberal takeover of higher and especially legal education here. It was a great event. Fusionism, as always, a topic I love to talk about, and it was great to hear your thoughts about it as well. But that's all kept, hush hush. It's what's spoken at Jacksonville stays in Jacksonville. So this is a book that's not merely addressing a public policy problem, but it's one that has a bit of a personal touch to it. Why don't you tell the audience who's not aware of your experience with a kind of cancel culture about what maybe was part of the motivation for this book? Yeah, this Lawless uses my so-called lived experience as a jumping off point for discussing problems with ideology, bureaucracy, failed leadership, all of these, the morass of pathologies in higher ed, and especially legal education. And I focus on that not simply because I'm a lawyer, but because while it's sad and unfortunate for human civilization if English or sociology departments go off the rails, law schools train the next generation of the gatekeepers of our legal and political institutions. So that's very important if they start, disbelieving in the objectivity of truth and the rule of law is illegitimate and all these. We'll get into that. But anyway, my personal experience, what launched this endeavor. I had been at the Cato Institute for nearly 15 years, and the opportunity presented itself to take my career in a new and exciting direction and join Georgetown Law School's faculty to direct their Center for the Constitution, which is an important center, as we've learned, because the rest of the law school is the center against the Constitution. So Randy Barnett hired me. He founded that center, a giant in the legal academic world, especially in the libertarian legal academic world, hired me to run the center, to teach some classes, have an inward-facing focus as well as an outward-facing focus to proselytize about originalism and so forth. A few days before I was due to take that job, I was due to start February 1st, 2022, was when Justice Breyer's retirement news broke. And my kind of day job, my bread and butter is as a follower and advocate before the Supreme Court. My previous book, Supreme Disorder, also still available, both in hard and soft cover. It talks about the politics of judicial nomination fights and all the rest of that. So I was doing media that day. I think it was January 27th. And I was on the road, happened to be on the road in Austin, Texas. If I was at home, this probably wouldn't have happened. The book wouldn't have happened because that night when I got back to my hotel room, I was doom scrolling Twitter, not a best practice. and becoming more and more upset about President Biden hewing to his campaign pledge to appoint a black woman to the Supreme Court. Now, there's nothing wrong in the abstract with appointing a black woman to the Supreme Court, but I think that I thought and still think that president should consider people of all backgrounds and not limit their candidates for any job, whether it be janitor or Supreme Court justice, based on race and sex. And so I was stewing in that upset and fired off an ill-advised hot take on Twitter, as we all tend to do, I think, from time to time. And I said, look, if I was a progressive Democratic president, I think I would appoint the chief judge of the D.C. Circuit, the second most powerful court in the land, a man by the name of Sri Srinivasan, happens to be an Indian American immigrant as well, but under today's hierarchy of intersectionality, that won't fly. And so we will be left with a, quote, lesser black woman, meaning that if it's not Srinivasan, as I was positing, everybody else was less qualified. But in the limitations of Twitter, the character limits and so forth, it came out as lesser black woman. And then I went to bed. And things blew up overnight. My ideological enemies called for my head. An investigation was launched. I mean, it was 4 days of hell for me personally. I wouldn't wish it on anyone other than the Twitter troll who launched all of this cancellation attempt against me, Slate's legal correspondent, Mark Joseph Stern. I felt my entire professional life crumbling before my eyes. Everything that I'd worked for decades, my parents' sacrifices and taking me out of the Soviet Union, it was terrible. It was god awful. And then the dean of Georgetown, Bill Traynor, after slandering me with his initial statements about how what I said was appalling and we can't tolerate, his saying that no black woman can ever be qualified for the court, which is not what I said. But anyway, he, instead of either firing me or vindicating me, saying, well, that's protected by our free speech policy, even if I don't agree with what he's saying or what have you, he took a middle course. He punted, as I've come to learn, higher ed officials, law school deans tend to do, and punted it to the DEI office and the human resources to investigate me for whether I violated Georgetown's harassment and anti-discrimination policies, which was bizarre because it was an investigation of a tweet. And you apply, these policies are very short and straightforward. So, you assign that to some junior law professor to look at it for half an hour and, come up with the conclusion. But no, it ended up being a 4-month so-called investigation with Zooms with these HR and DEI people with just, banal questions and what have you, which I detail in the book. At the end of which, this 4 months of purgatory, if you will, that followed the 4 days of hell, some junior associate in the big, expensive D.C. law firm that Georgetown hired to advise them, Wilmer Hale, looked at the calendar and realized I was not an employee of Georgetown when I tweeted, and therefore these policies don't even apply to me. They don't have jurisdiction, as it were. And so I was reinstated on that technicality. It wasn't a vindication of free speech or anything else. So I celebrated that, but then I read the fine print, this 10-page report from the Office of Institutional Diversity, Equity, and Affirmative Action, which said that if I were to say something equivalent that caused offense, then I would be creating a hostile educational environment, and I would be back in the Star Chamber. Taking advice of counsel and Professor Barnett and my wife, who's a better lawyer than all of us, I realized I simply could not continue. It was untenable. I would not be able to do the job I was hired for, whether in terms of writing op-eds or commenting in the media about, say, the challenge to Harvard's affirmative action program that was ongoing in the Supreme Court at the time, or other cases involving, I don't know, a graphic designer who didn't want to create a web page for a same-sex wedding, or any of these kind of sensitive, controversial, political, legal issues. I'd be, somebody would call offense. There'd be another letter writing campaign, and away we'd go. So I realized that I had to quit, I had to resign. And as we lawyers do, I made a loud exit. I published my resignation letter in the Wall Street Journal, as one does, announced my next move to the Manhattan Institute on Tucker Carlson's show on Fox News, as one does, and I've been using this platform I've been given ever since to shine a light on the rot in academia and sound the alarm about these weaknesses in ideology, bureaucracy, leadership. Never intended to be a poster boy for cancel culture, but they tried to cancel me. I canceled them, and here we are.
So a big question I always had for you about this experience was, to what degree did you have really any confidence in the ability for a DEI office at Georgetown to actually promote diversity, equity, and inclusion? Because it seems to me that its true operation was to enforce a kind of ideological monoculture or compliance, and do so by creating a kind of process is the punishment situation where you're going through all of these meetings. Is it really, even trying to promote real diversity, equity, and inclusion, or is it just like you said, a star chamber meant to extract judgment without due process?
Well, as I write in Lawless, this is based in good intentions. I'm not saying that these inquisitors have malevolent motives. I mean, they might not have liked me because they didn't like my comments that didn't fit into their rubric of privilege hierarchy or whatever. But they want to make America a better place. They want to make Georgetown a better place, and so forth. But globally speaking, these DEI offices fail on their own terms. That is, campus climate surveys. Now, I'm no statistician, so I can't say it, definitively, but there's no correlation between the size of a DEI office or the number of staff or its budget and an increase in student feelings of belonging or comfort with diversity. In fact, there's some indication articles that I've read that seem to say that there's an inverse relationship. So far from, failing, they actually cause harm in the very things that they would be doing. And certainly my experience with this office, it was, after a while, after the shock of whether my whole professional career would crumble, and I started getting speaking invites and job offers and writing invites and things, my lawyer gave me the green light eventually just to keep doing my job, speaking about the Supreme Court and legal issues, not talking about the investigation or Georgetown, but, do my normal, job. It became clear the longer this went that it was just a farce. And not that I was expecting very much of it going in, but to drag on for months and months, and it became apparent that the dean was just waiting for the students to get off campus. So when he made his eventual, announcement, there wouldn't be, mass protests and what have you. It was another aspect of this profile and courage that's a problem. So no, these DEI offices are just again, I'm not saying these actors are all evil or what have you, but the whole institution, they even have an industry group. It's the association, I forget what the actual name, it's something like the Association of Human Resources Professionals for Diversity Offices or something like that. Thousands of members. And like the great political economist Mansur Olson liked to say, the growth of bureaucracy is the decline of nations. And so similarly, this educational bureaucracy, whether with private schools or public schools, is very much to the detriment of the core mission of a open inquiry, advancing human knowledge, in this case, teaching lawyers.
Yeah, the cultural climate of academic research is supposed to be one of relative openness and tolerance because of the diversity of views and the multiplicity of disciplinary approaches. But it seems like there's an attempt to kind of enforce a kind of orthodoxy here, maybe not with, like, as you said, bad intentions, but at least with unintended consequences. Did you find that your colleagues were at Georgetown were at all concerned about these restrictions on them, or were they advocates for them?
Very few people who supported me at Georgetown took public positions or even emailed the faculty listserv. Nick Rosenkrantz is one. Randy Barnett was, in a delicate situation. He was, working on the dean. There's no need for him. He was hiring me. It's, he was necessarily played a different sort of role. But no, the Georgetown faculty, most of, there were kind of the attack dogs who said I should be fired. David Cole, a legal director of the ACLU, who's always also on faculty at Georgetown, said that what I said was, definitely terrible, maybe racist, but I shouldn't be fired over it. So, okay, that kind of process argument is perfectly fine. But most people just kind of, as you say, this toxic climate on campus, most people are just trying to keep their head down and not get caught in the cancellation crossfire.
Yeah, that is something I've really worried about because the purpose of university administrations, especially at universities as prestigious and long-lived as Georgetown, is to preserve the academic climate for faculty research and for student learning. And from what I gather, that is the opposite of what they're interested in here. They're really much more interested in sacrificing those two ends for the purposes of avoiding bad press and avoiding potential lawsuits. And it seems to me that sticking to your guns and showing that you will so is probably better for both of those purposes, both the academic mission and for avoiding lawsuits. If you're willing to say that I'm going to play this game too, I will defend myself, I'll defend my faculty, I'll defend my students, you actually discourage people from coming after you. But because of all the caving, people know that it works. And so they'll push even for something as absurd as trying to go for your ouster and then succeed. It's kind of maddening.
Well, to be clear, they didn't oust me. I harmed, gave a black eye to Georgetown and to Dean Traynor and everyone involved there. Alumni still, question him. There's an impact on donations, I understand. He apparently curses my name and things like this.
But as it should be, right? Like
right. Yeah.
This is unacceptable behavior.
No, I mean,
they don't deserve it.
Karma is real. Apparently, this is not confirmed, but I was speaking at Fordham Law School soon after all of it concluded, and the scuttlebutt is that Traynor lost out on Fordham's presidency in large part over how he handled my case. He had come to Georgetown from being dean of Fordham Law, and then he was up for the presidency and lost out on it. But anyway, all I did was not quit right away and not grovel and bend the knee. And, I was invited to I did apologize for poor communication. I said, that was a poorly phrased tweet. I should have said it a different way. And that's it. I was invited to apologize further and start talking about systemic racism and all these other tropes. I declined to do that. And so just by holding out and saying, nope, I've got nothing, just by holding out until they had to make a decision one way or another, ended up being the right thing. But you're right that university administrators, whether law school deans, department chairs, provosts, presidents, these are largely not woke radicals or social justice warriors.
Right.
They're careerist bureaucrats. And what they have to do to actually they could do well by doing good. That is, the right thing to do would help them both with PR, donations, all these other things. If they have a policy and an established enforcement practice of not allowing these cancel culture inquisitions, what have you, to go on to actually promote a culture of open inquiry and discourse and academic freedom, then that's better on all sides. You see that from, say, the late Bob Zimmer at the University of Chicago, or the University of Chicago more broadly, which has been largely immune from these sorts of controversies. That happens to be my law school alma mater, so I'm proud of that. Or David Diermeyer, the chancellor of Vanderbilt, who's gotten national plaudits for kicking students out of his office who took it over during the pro-Hamas encampments and all of that. Or Ben Sass, when he was president of the University of Florida, how he handled certain protests versus, say, what happened at Columbia. I mean, it is not a high bar. It's not rocket science. You don't have to develop whole new complicated theory or new policies to deal with these sorts of issues. It's just apply existing rules. Georgetown's free speech policy does not need fixing. It's great on paper, on pixels, but Dean Traynor the whole time was kind of wringing his hands through his final statement when he reinstated me, wringing his hands about how difficult these issues are because it presents a tension between our core values of free speech and equity. Well, no. I mean, who exactly was I harassing? Joe Biden? I'm not exactly sure how all of that is supposed to work. And so these careerist bureaucrats turn out to be, in large part, spineless cowards. And that weakness encourages a further breakdown in the campus community where, I've kept speaking in law schools and other academic settings, and university leaders come up to me and say, what should we do? I'm like, well, enforce your rules, create a culture, foment. You're very good. University leaders are very good at sending emails, having trainings, just establishing cultures to advance, whether it be public service, environmentalism, entrepreneurship, whatever your values are of your institution. They're good at doing that. Well, free speech, academic freedom, these sorts of things, tolerance of views you don't agree with, they can do that. But in so many cases, they just don't.
Yeah, and it's also an immense waste of everyone's time. So, you would think these people would have more vacation days available to them if they didn't make everyone sit in Zoom calls. They could just take the afternoon off instead. But
that was actually, you mentioned Zoom calls and the meetings with the inquisitors. This is the other kind of extra perverse dimension to all this, or bizarre or ridiculous. So this is spring of 2022. And Georgetown still had heavy COVID restrictions. So I never actually met in person with Dean Traynor, with the DEI officer, anybody else, because we would have had to have been wearing masks if that was the case. So all of this was done over Zoom.
Which makes it all the more surreal and disembodied, literally. So, this isn't just about your particular case, but also how this case prompted you to take a very hard look at legal education, big part of what you've written here. So why don't you talk about the law school and how, as an institution in the United States, and how this approach has really made its way into forming its graduates?
Yeah, so it used to be, if anyone's watched the movie The Paper Chase, which I encourage, it's a movie from the 70s about Harvard Law School, and kind of this Professor Kingsfield, this very old school professor, uses the Socratic method, asking questions of students to get to the ultimate point of his teaching. And, law school used to be, you kind of, the first year you ran this cursus honorum. Everybody takes torts and property, contract, constitutional law, criminal law, legal writing. That's it. Everybody takes the same thing. You run that rigorous gamut. And then, for me personally, that still was the case when I was a 1L. For me, I don't think I necessarily got it, but it 1L ended, and I passed and I survived. And then you go into your second year and you take kind of more doctrinal electives, securities law, other topics in constitutional law, international law, these kind of standard things. And then the third year, it's kind of more wide ranging. You either do independent studies and writing papers, or you take kind of these more esoteric subjects, sports law, say, entertainment law, advanced security, whatever, things like that. And it was all to understand and inculcate how our institutions work, the post-Enlightenment tradition that the founders established, how our system of government works from a legal perspective, how to advocate zealously from your client, understand different perspectives, all of these sorts of things. And that has shifted. Now, in many ways, students are taught to question the legitimacy of the law and the legal institutions itself. It's bizarre. It's dangerous because if all of our institutions, say, are irrevocably imbued with racism, sexism, patriarchy, all of these different things, they need to be deconstructed and reconstructed in kind of a year zero revolutionary zeal. It's very much like the Chinese Cultural Revolution or the French Revolution or what have you. That doesn't say good things about these graduates, whether they're going to be prosecutors, public defenders, judges, general counsels of companies, nonprofits, what have you. I mean, it's undermines the whole basis of American freedom, prosperity, equality, what have you. I mean, the notion that equality under the law is a white supremacist dog whistle. These are these sorts of things that these postmodern theories come up with. And I'll tell you, when I was in law school in the early 2000s, these kinds of this comes from critical legal studies, from which
Right.
critical race theory and queer theory are kind of offshoots. We thought of these crits as kind of a spent force. Now, that was something from the 80s, early 90s, these weird flare-up of theories that had been long relegated to the sociology departments or what have you. But it turns out that, as one of the chapters in my book, Lawless, is called, critical theory returned with a vengeance. And so, especially in the last 10 years or so, the Obama administration's worsening of race relations, the Ferguson effect from 2014, social media, and the work that Jonathan Haidt and Greg Lukianoff have documented about how that generation has kind of approaches things differently, is culturated differently. The election of Donald Trump, COVID, the killing of George Floyd, all of these things kind of changed all of society, but really affected law schools in that particular way, in a very negative way. And so that is to the point where, as I write, Derek Bell and Kimberly Crenshaw, kind of the founders of critical race theory, have replaced Louis Brandeis and William Blackstone as avatars of legal education, which is very dangerous.
Yeah. What do you think of this? Is something I've thought about a few times, which is that the critical approach is really just one theory that you can apply from a bunch of different vantages, right? So you can do critical race or critical queer or whatever. So it's actually kind of easier than the cursus honorum that you just mentioned. That's hard. It's hard to teach and it's hard to learn. And so this might actually reflect a desire from both the faculty and the students just to have to do less work. Is this maybe what's going on here, or is it that there's a demand for this kind of education rather than demand for someone who does securities and torts?
Never discount the laziness of either students or professors, for sure.
As a professor, I never discount it. I know myself too well.
Yeah, there's an intellectual laziness, and there's also just a laziness in general. I think that's part of it. Another part of it is bureaucracy, because we've just been talking about the theory and the ideology from an academic perspective and what's taught, but something which gets covered a fair bit, but something that is less sexy is the bureaucratic growth, and how there are now in every institution's more non-teaching administrators, staff, than teaching faculty. So whatever is going on with the faculty in terms of ideological discrimination in hiring, types of courses that are offered, how law is taught, the fact that even though a majority of the Supreme Court and half the judiciary in general are originalists, but originalism is at best taught as in some sort of sneering, snide way that really is a detriment to the students. But setting aside that academic intellectual part, the fact that the bureaucracies have exploded, and in the last decade, most of that bloat has come in the DEI space, really does a further disservice. And it's made these non-teaching staff who are not imbued or raised up in academic virtues, academic values, is really troubling. Because you have these structures, and again, these deans who are inculcating culture and what have you, having trainings, having all sorts of organizational sessions, orientations, hand holding, the safetyism and the therapizing of education, of higher ed, where students need a crying room to process the trauma of not just exam season, which is how all this started off 20 years ago or what have you, but elections that didn't go their way, or the presence on campus of someone like me or someone else, Judge Kyle Duncan at Stanford, who got shouted down because it's just these bizarre trends, which are driven by bureaucracy, even beyond, again, what the concerns that definitely exist from the academic faculty perspective.
And students certainly know how to respond to those incentives, where a bureaucracy that's mostly afraid of liability or complaint will leverage that administration against their own faculty members. So the faculty will end up caving, lowering standards. And this is occurring even at elite institutions. What does this mean then for the next generation of attorneys and judges that are forthcoming?
Right. I mean, even the deans of elite law schools cow at their supposed underlings who run the DEI offices or the university-wide ones. What it means is that students are not well prepared to execute their jobs. If it's triggering and unsafe and improper to teach, I don't know, the arguments against gay marriage, say, or about the graphic designer or the cake baker that doesn't want to work a gay marriage or what have you, or the pro Second Amendment arguments, or in all of these spaces, the so-called politically incorrect positions, just so you can understand them, so you can be a more effective argument for your progressive side. No, we can't do that. It makes for less effective lawyers. It also makes for legislators and developments in the criminal and civil justice space that is really detrimental to society. For example, sentencing based on race. In Canada, for example, certain places in California, you will get different sentences for the exact same behavior between two criminal defendants. The same behavior, same criminal record, they will be sentenced differently depending on what race they are. It's the antithesis of equal justice under the law, for example. One other thing here I should mention, we've been talking about, the head deans, we've been talking about DEI offices. The admissions office is also a component here in that, especially at the elite places, your Yales, your Stanfords, they screen for activists rather than scholars. And so if you write in your personal statement, I want to change the world, I want to radically restructure these illegitimate institutions, what have you, that's going to give you a leg up. Versus if you say, well, I want to prosecute child molesters, or I want to work on corporate antitrust to make corporations, American free enterprise, more efficient and fair for the consumer, or something like that. There are even these, sometimes they make headlines where somebody wrote Black Lives Matter 250 times in their personal statement, and then they got into, I forget whether it was Stanford or Yale, but these sorts of things. So admissions offices are also to blame in this degeneration of our system.
There's a weird problem with this where you have in the law school sort of market, right, of students and faculty, the most elite universities are experiencing even higher rates of application, and then lower ranked ones are actually starting to kind of starve. But the question then becomes, are these elite institutions receiving high rates of application? Are they really elite if they're not doing the job that you said they do, and they're producing inferior attorneys, people who, we could even joke that it's a vast right-wing conspiracy to make the left's attorneys worse. But that's not it, right? It's actually like internal incentives, as we talked about before. So would you really call Yale Law School an elite institution if it doesn't even teach torts its first year and can't even comprehend defending the Second Amendment rights that the Constitution currently upholds?
Well, we've seen society-wide the decline in respect and confidence in, institutions generally, but certainly higher ed more than most institutions. This has been especially highlighted since October 7th. How is it that anti-Semitism, the heart of anti-Semitism in our country, is based in the most progressive, so-called educated spaces, and where, as Bill Ackman wrote in his evocative essay that came out the same day that Claudine Gay resigned the presidency of Harvard, that anti-Semitism is the canary in the coal mine, kind of the tip of the iceberg that signals pathologies that are there underneath. And so the crisis in higher ed is very much in our national public discourse now. You're right. The places that don't merit respect are declining in respect. Conversely, places that, again, it's a low bar where their leaders are actually doing their job and preserving the core truth-seeking mission of any institution, or preserving the teaching of law and respect for the rule of law and things like that, are relatively rising. They're playing Moneyball. They're your University of Chicago, your UVA, your Scalia Law School at George Mason are able to hire professors, are able to entice students that perhaps they wouldn't if your Harvard, Yale, Stanford, Columbia were less pathological.
You saw the appointment of the first non-Yale Harvard Supreme Court justice with Amy Coney Barrett. But is her appointment kind of a sign that we're no longer being held hostage to this duopoly because the products of that duopoly aren't really what they used to be?
I think there has been a bit of a vibe shift, if you will. And indeed, in general, the last decade, more students from, below the top 10 or so schools have been hired to be clerks for the Supreme Court, for example, and other similarly prestigious positions, which makes sense because your top person or your top, 5% at Notre Dame or Alabama or, any number of schools that are still good, but not US News doesn't consider them to be top 10 or whatever, are going to be better than your average person, say, at Yale or Stanford. And I think that recognition is out there. A bit of a democratization, if you will, a bit of a decline in the fetishization of these other schools. But I'm seeing some green shoots even at these properly maligned schools. For example, Heather Gerken, who is the dean of Yale Law, and is one of those careerist bureaucrats who does want to climb that greasy pole even further to become president of one of these Ivy League institutions. She has seen the hits that Yale Law has taken, and so recently hired Keith Whittington away from Princeton to give him a bunch of money to do a free speech academic freedom center and other programming, and not just senior established faculty. Hired a young junior professor who had clerked for Alito, of all things, I believe in the same year that Dobbs even came down, the overturning of Roe v. Wade. So something like that would not have happened had it not been for all of this bad publicity, or for that matter, the dozen or 14 federal judges that said, because of your bad free speech climate at Yale, we're not going to be hiring clerks from there. My friend Judge Jim Ho of the Fifth Circuit and Lisa Branch of the 11th have led that effort, and then added Stanford after the shouting down of Kyle Duncan, added Columbia after their terrible policies with regard to anti-Semitism. Those sorts of things are having an effect. I'm an all of the above kind of person. So we should try lots of different things, both internally and, as economists would say, exogenous shocks to try to force reforms in these institutions.
I've heard more than once from people who've worked in the judiciary that it's actually very difficult sometimes to take sort of traditional elite, 1L or 2L students into their summer clerkships. You essentially have to reteach them or even engage in a kind of new teaching that they didn't get but were supposed to get in order for them to be qualified clerks. And judges don't always have time for that. So it makes sense that they would do this, not just because of a kind of ideological counterattack, but because they need to get their jobs done, and these clerks aren't doing their jobs. It's kind of breathtaking that it's taken this long for law schools to respond to these incentives. But it's one thing to get negative write-ups in the conservative press, but it's another when federal judges won't take your students anymore. That's really hitting them in the where they live.
Or employers, after October 7th, the top law firms, 100 top law firms, 200 top law firms in the country had an open letter to the deans of law schools saying, we can't hire people who protest in favor of Hamas and, baby killers and all the rest of it. I don't know what you're doing, what kind of culture you have, but you have some problems. Go fix it. And these are not right-wing institutions. The nation's leading law firms are, 95% donate to the Democratic Party, et cetera. But they recognize that, they want students that actually, know how to write a memo, and B, are not going to be just inveterate bigots of that sort. And that's heartening to see, because there is a bit of a problem otherwise in the sense that there's some thinking that, like in the 50s and 60s, law firms would say that, we would love to hire black lawyers, but our clients don't want them. That kind of excuse is hard to maintain these days.
So, as we wrap things up, what is really the future for all of this? One theory I've heard many times is that this kind of a heavy administrative bloat, DEI focused university was a product of 0% interest rates And as like things actually become more expensive and we start to hit a kind of a cliff in student enrollment because of a population decline after the housing crisis, the justification for having all these effectively unproductive administrators on staff really goes down the tubes. But on the other hand, they're the ones who make a lot of the hiring decisions. So you end up with maybe law schools without faculty. What do you think is going to happen here? There's a pretty wide open situation here.
Well, who was it that said that something that can't go on won't? Is that one of Herbert Stein's maxims? I think.
Yeah.
Ben Stein's father. Yeah, I mean, at a certain point, it's going to take. We haven't talked about the Department of Education, but they can do various steps in terms of investigating and actually withholding funds, not having these sweetheart settlements as we've seen from the Biden administration as it's going out the door, of places that deny their students their civil rights, their free speech rights, and all the rest of it, or removing the ABA's accreditation monopoly, for example. There actually is some accreditation competition among, say, liberal arts colleges, but there's not in law schools. The ABA is the only game in town, and that's bad. I have a whole chapter in my book Lawless on the perversions and foibles of the ABA. The education department could get rid of that. You don't need new legislation to do that. So I think as there's a recognition that some institutions are better than others, both from students, from employers, we are going to have probably some shifts. And state legislatures, for that matter, with respect to public schools at least, have a role to play, not in dictating what gets taught in the classroom, but in eliminating offices that are counterproductive and not funding structures that are value subtracting. So just like they can decide that this school is going to focus on STEM, that school is going to focus on liberal arts. We don't want these DEI structures. We don't want diversity statements in hiring. There's certain things there's a role to play for both the public and private sectors.
Actually, before we go, I want you to say something about the ABA, since you do have a whole chapter on it, and I'm sort of skipping that. It's this problem with the monopoly and the ABA in terms of its accreditation. What would be an alternative, or is there an emerging alternative potentially for accrediting law schools?
Well, if within any state, the state bar, which is typically answers to the state Supreme Court, can, for purposes of practicing law within that state, say you don't have to go to an ABA accredited law school. I think that's only in place in California, ironically, perhaps. But other states could do that. But other states could also, if the education department removes the accreditation monopoly, they could find other ways to accredit. There would be other accreditors or certifiers that would spring up, and schools could say, well, I'm approved by the Liberty Fund, or I'm approved by this other new accreditor, and the state Supreme Court could figure out, how they want to, who exactly they want to allow to practice law, to get a law license in that state. States can get together in an interstate compact to have reciprocity in that regard, but you would have a burgeoning market, a competition in accreditors that simply can't exist right now.
So this is something I didn't know. I did not know that this was a federally backed monopoly through the bar. Am I understanding this?
Yeah. The education department accredits accreditors, if you will, gives their stamp of approval that you have the right to accredit these institutions for them to get federal funds and things like that.
Fascinating. This is actually like a really great idea.
And just so neither I nor anybody else needs to reinvent the wheel, the Defending Freedom Institute, my friend Bob Eitel over there has been doing great work, has put out a couple of studies about reforming accreditation. It's a really wonky, really nerdy subject, obviously, but the work is all there.
The book is Lawless, The Miseducation of America's Elites. The author is Ilya Shapiro. Thank you so much for appearing on the Law and Liberty podcast.
Well, thank you. And in case you want to find me, your listeners want to find me, I also have a Substack, Shapiro's Gavel. You can also go to the website of the Manhattan Institute, which is simply manhattan.institute. You might not be aware that .institute is a suffix. You don't need org or com or whatever. And you can find me on X, formerly Twitter, @iShapiro.
The man himself. Thank you so much. Thanks for listening to this episode of Law and Liberty Podcast. Be sure to subscribe on Apple, Spotify, or wherever you get your podcasts, and visit us online at www.lawliberty.org.